Yes.
For judgment, item number 1.
In view of the discussion and observations made above, the writ petition is allowed. Impugn order dated 11/2/21 is quashed and set aside. However, the parties are directed to maintain status quo over the suit land till such time either party approaches a competent civil court for declaration of right, title, and interest.
Obliged, ma'am.
Remaining pages are saying the chapter.
No, please, Your
Yes.
Lordship. I may be allowed to mention item 45 and 46.
45 and
46.
46.
May I pray that these
Yes.
matters be listed after 4 weeks.
I have no objection. Learned counsel for the respondent. These are analogous matters.
Yes, these two are analogous.
For the respondent, Mr. Eli Ralu, who makes a mention for listing the matters after 2 weeks. 2 weeks?
4 weeks.
After 4 weeks. So, learned government advocate as well as the learned counsel for the petitioner, Ms. Lucino has no objections. List after 4 weeks. Yes.
May I also be allowed to mention item 23? If this can come up after 2 weeks.
23.
23.
Here also for respondent
For the respondent, private respondent.
and petitioner. No objection.
No objection.
This one also 4
Yes,
weeks.
2 weeks.
2 weeks. List after 2 weeks under prayer of the learned counsel for the respondent, Mr. R. Ralu, which is not objected to by learned counsel for the petitioner. Yes.
No.
Please, Your Lordship. Lady, if I may be allowed to make a mention of item number 48. 48 here.
Yes.
My senior, Mr. Imti Longjam, is indisposed. So if this matter can come up after 4 weeks, my lady.
Learned counsel for the petitioner, Ms. Lucino, who makes a mention on behalf of the leading counsel, Mr. Imti Longjam, who is indisposed. Accordingly, list after 4 weeks. Yes.
Obliged.
Please, my lady,
Yes.
I'd like to mention item number 25.
Yes.
Ladyship, I'm yet to receive instructions, so can you grant me 3 weeks time?
3 weeks.
Yes, ladyship.
Yes.
No objection.
Learned counsel for the petitioner, Mr. Eli Ralu is present. Stop learned government advocate, Mr. Kiangami, prays for 3 weeks' time to file the affidavit on behalf of the state respondents. Stop. Accordingly, list after 3 weeks.
Ladyship,
Yes.
I have a similar prayer for item number 31, 31. I've taken the
3
consent.
weeks.
Yes.
3 weeks.
Like-
Petitioner?
I've taken the consent.
Okay. The consent of the petitioner has been taken in 3 weeks. Okay. Yes.
May I please, Lordship? Your Lordship, I beg to mention item number 49. Kindly allow the matter to be listed after 3 weeks.
3 weeks.
Yes, Your Lordship.
Item 49. On the prayer of the learned counsel for the petitioner, list the matter after 3 weeks. Yes.
Much appreciated.
May I please, Your Honor? I beg to mention item 36 on behalf of Pichano, government advocate. We are yet to receive instructions. So we pray for 3 weeks, Your Honor.
Learned counsel for the petitioner, Ms. Such present. Learned government advocate, Mr. M. Longcomer, prays for 3 weeks' time to file the affidavit on behalf of Ms. Pichano, learned government advocate. Praise the Lord, list after 3 weeks.
I have a similar prayer for item 37 and 38 on
Behalf of Pichano.
Yes.
Okay, 37 and 38 also on behalf of Pichano after 3 weeks. Yes.
obliged.
May I please, Your Lordship?
Yes.
I'd like to mention item number 54.
54.
For the respondent here, if this matter can be listed on 24th of November. I've taken consent of the opposite party.
Learned counsel and Mr. Such appearing for the
54.
respondent.
54.
Praise for listing the matter on 24/11/2025. It is submitted that the learned counsel for the petitioner has no objections.
Your Lordship, there is an interim.
The interim order passed earlier shall continue till the next date.
Obliged.
Please, Your Ladyship, I beg to mention item numbers 56 to 60. We have filed our affidavit in reply and pleadings are completed, so I pray that this matter may be listed for hearing on after 2 weeks.
56 to 60.
Yes, Your Ladyship.
Okay, you are for the petitioner.
Yes, Your Ladyship.
You want to file a reply?
We have already filed
You have already
and
filed.
pleadings have been completed.
Okay, so when do you want
After 2 weeks.
hearing?
Yes, Your Lordship.
Learned counsel for the petitioner and Ms. Sergeant is present. It is submitted that the pleadings are completed as the reply has already been filed by the petitioner. Accordingly, she has prayed for listing the matter for admission hearing after 2 weeks. So, learned counsel, learned government advocate, Mr. Sergeant Such, has no objections. List after 2 weeks in the admission column.
Much obliged.
Yeah, please, Your Lordship. May be pleased to mention item number 26 on behalf of AIM, Your Lordship. Your Lordship, 3 weeks may be given for filing of affidavit, Your Lordship.
Learned counsel, learned government advocate, Ms. Livika makes a prayer on behalf of Ms. AIME to list the matter after 3 weeks in order to enable the government to file the counter affidavit. So, prayer is allowed. Learned counsel for the petitioner has no objection. List after 3 weeks.
Your Lordship, I have a similar prayer on behalf of AIME, item number 29, 3351, Your Lordship.
3 weeks.
Yes, all 3 weeks. Item 29,
In 29, I may also be allowed 3 weeks for the private respondent.
Okay. In 29, prayer is made by the learned counsel for the private respondent, Mr. L. Iralu, as well as Ms. Livika, for 3 weeks' time to file the affidavit in opposition. Stop. Learned counsel for the petitioner is present and has no objection. List after 3 weeks. And then the
item
other-
33,
item 33,
and item 51
51.
on behalf of AIME. 3
3
weeks.
weeks.
Yes, sir.
Same order on behalf of AIM, 3 weeks.
Your
Yes.
Lordship, there's an interim order in item number 33.
In
Kindly let it
23.
continue.
Oh, 23. The interim order passed earlier shall continue till the next date. Yes.
Much obliged.
Please, Your Lordship, I beg to mention item number 3 to 22.
Item 3.
3 to 22.
Okay.
I pray that 3 weeks' time may be granted to file affidavit and reply.
You're appearing for?
I'm appearing for the petitioner.
You want to file a reply?
Yeah, affidavit of reply, yeah.
Reply.
Reply already filed.
Okay.
Your Lordship, here in this matter, the similar matter has been perfect and appealed by the state government. Similar matter. So a time will be granted.
3 weeks, my lord. I'm appearing
Okay,
for
we'll
respondents.
list after 3 weeks. Let's see.
Yes.
Okay.
Respondents 1, 2, and 3 in all the cases.
1, 2, and 3. Yes. Learned counsel for the petitioner submits that the affidavit in reply has been filed.
It's yet to be
Is
filed.
yet to be filed by the petitioners, and accordingly she prays for 3 weeks' time to file the affidavit in reply to the counter filed by the government respondent as well as the respondent number 1, 2, and 3. Stop. Prayer is allowed. This is the matter after 3 weeks. Learned counsel, Mr. Sintiang appears for respondent number 1, 2, and 3, and additional AG, Mr. Im Tim Song for the state respondents. Yes.
Be obliged.
I beg to mention item number 30.
Item number
30. 30. 30.
Yes,
I pray that 3 weeks' time may be granted to file affidavit in opposition.
3 weeks.
Yes, Your Lordship.
You're for R
I'm for respondent number 6.
6.
Yes, Your Lordship.
Learned counsel and Ms. Sergeant Such prays for 3 weeks' time to file affidavit in opposition on behalf of respondent number 6. Stop. Learned counsel for the petitioner. Ms. Sergeant Such is present. Government, who's appearing? The government is represented by Mr. Sergeant Such. List after 3 weeks. Government has filed.
No, no.
List after 3 weeks in order to enable the government respondents as well as the respondent number 6 to file the affidavit in opposition. The interim order passed earlier shall continue till the next date. Yes.
May I please, Your Lordship?
Yes.
Lordship, I would like to mention unlisted matter to move today. There's some urgency. The matter relates to criminal petition and then check bounce. So I want to move today itself. So
Tomorrow?
tomorrow.
Tomorrow, okay. Just give the mention.
Wait, please, the report. Your Lordship, I beg to mention item number 28 on behalf of my senior, Gauhati. Your Lordship, this matter may kindly be fixed after 3 weeks as we are yet to receive instruction.
Learned counsel for the petitioner, Mr. Moy Jamu is present. Learned counsel, Mr. Such and Such makes a mention on behalf of the learned CJC, Mr. Gauhati, and prays for 3 weeks' time to receive instructions and to file the affidavit on behalf of the government, on behalf of the Union of India. So accordingly, list after 3 weeks. Yes.
What's your Lordship?
May I please, Your Lordship? Lordship, I beg to mention item number 34. Here I am yet to receive instructions, so kindly grant me 3 weeks of time to file my affidavit. 34 and 35, similar prayer.
34 and 35. Learned Government Advocate, I forget your name.
Yes, it's Achumna.
Chungli Sanktam, no?
Lordship.
Prays for 3 weeks' time to file affidavit on behalf of the state respondents. So, learned counsel for the petitioner, Mr. L. Kom is present, and there's no objection. List after 3 weeks. Yes. 34 and 35. Okay?
35, I'm appearing.
Oh, okay, okay. In 35, Mr. Sintianger appears for the petitioner, and there's no objections.
And Lordship, I beg to mention item 27, behalf of S. Chang. Here she is yet to receive instructions, so kindly grant 3 weeks of time to file affidavit.
Prayer is made on behalf of Ms. S. Chang, Learned Government Advocate, to list the matter after 3 weeks in order to enable the state respondent to file the counter affidavit. Stop list after 3 weeks as prayed for. Learned counsel for the petitioner is present. Yes, Ms. Such and Such. Yes.
Lordship, I beg to mention item number 47, hearing. Lordship, here today, Vizimomi, here the personal difficulties. So,
47.
yes, Lordship. So kindly grant
Who
2
has
weeks.
difficulties? Vizimomi.
Lordship,
Okay. Yes.
I'm appearing as Amaikas
Okay.
for the victim.
In 47.
Yes, ma'am.
Lordship,
What about appellant?
47.
Mr. Medo Vero. Learned counsel for the appellant is not present when the matter is called. Learned amicus, Mr. Sintianger appears for the informant / victim. Learned.
Hello, the
government-
appellant is here.
Oh, okay.
I am for the appellant.
Okay, okay.
But I have come down from all the way from Gauhati for this hearing. Because I was sure the amicus curiae, he was ready to hear the matter. Yes, I am ready in fact.
The PP is not there.
Yes, Lordship. Unfortunate today. Because of his health.
Oh, in this post.
Yes, Lordship.
Let's refix it. Without PP, how can we hear? Yes.
2 weeks, Lordship.
Okay, Leonard, we'll have to give a fixed date since it's coming from a second.
Yeah.
Leonard, okay, then delete that. Leonard counsel for the appellant, Mr. Such and Such, your name is present. Is present. Stop. Leonard amicus, Mr. Sintiang is present. However, it is submitted that the PP, Mr. V. Momi, who is appearing in this matter, is indisposed today. And accordingly, it is prayed that the matter will be listed after 2 weeks. Stop. Accordingly, prayer is allowed. List on.
Give them.
Yes, give a date after 2 weeks.
Month of December.
24th, 5th.
November, December. 9. Okay.
Okay. List on 9th December. Yes.
Hello, back.
This is your life. Problem.
Okay. Item 50. This matter was after 4 weeks.
Which one?
50. 50.
50. After 4 weeks. Item 50, 50, on the prayer of the learned counsel for the petitioner, Mr. L. Iralu, is the matter after 4 weeks for hearing. The interim order passed earlier shall continue for the next time.
May I please, Your Lordship? I beg to mention item 32, Your Lordship. Here I am yet to receive instructions.
I'm appearing in item number 32, my lord.
To receive instructions and to file counter, Your Lordship.
How much time?
3 weeks, Your Lordship.
3 weeks.
I'm appearing for item 32, my lord.
Okay.
Online.
Okay.
Last two occasions, they have sought time for 4 weeks each, my lord.
Your Lordship, here I received the service copy very late, Your Lordship, after a month, Your Lordship. So, and after that, the ongoing strike, Your Lordship. That's why I'm unable to receive the instructions as well, Your Lordship.
Yes.
It was the
Actually,
petitioner.
there's a pen down strike going on by the government employees. That's why they
I am
are.
not opposing the adjournment as such, my lord, by shorter adjournment and be it by final, my lord.
Your Lordship, they have served me a service copy very late as well, Lordship. That was the. They had served
did
me.
you receive?
It was moved on 15, Your Lordship. I received on 10th of October, Your Lordship. Your Lordship, on 7th of October, Your Lordship.
Learned Counsel for the petitioner. Your name?
My name is Balaji Verma.
Okay,
P.
Balaji.
Balaji Verma from Hyderabad.
P. Balaji Verma is present through VC. Stop. Learned Government Advocate Ms. Inauli submits that the service copy was received very late after
On 7th of
only
October.
on 7th of October, and therefore she is yet to receive the instructions from the respondents. Stop. It is therefore prayed that she may be given 3 weeks' time to receive instructions and to file the affidavit in opposition. Stop. Prayers allowed list after 3 weeks.
Much obliged.
Obliged, ma'am.
May I please, my lord. My lord, I beg to mention item number 52, my lord. My lord, I pray that may this matter be listed on 9th of December, my lord.
This is analogous 52 and 53.
Yes, 52, 53.
Learned Counsel for, you are for?
Correspondent number 4.
Learned Counsel, such and such, appearing for respondent number 4. Prays for listing the matter on 9th of December for hearing. The prayer is not objected to by the Learned Counsel for the petitioner, Ms. Such and such, and the Learned Government, Senior Government Advocate, Mr. K. Hangam. So, accordingly, list on 9th December.
Much obliged, my lord.
Leadership, there's an interim, if it may be continued.
The interim order passed earlier shall continue till the next date. Yes.
May it please, Your Lordship, I beg to mention hearing item 51.
Your Lordship, I mentioned the item
It's already
51.
mentioned.
Yes, item 51 on behalf of IME, but it seems the petitioner wants to withdraw the case, Your Lordship.
Withdraw.
Yes, Your Lordship.
51.
Yes, Your
Okay, Learned Counsel for the petitioner, you are Miss
Rebecca.
Rebecca submits that she would like to withdraw the present writ petition. Stop. Accordingly, the petition is disposed of on withdrawal. Yes.
Much obliged, Your Lordship.
Please, Your Lordship.
Yes.
Lordship, I beg to mention for item number 43 and 44. Lordship, here in one similar matter, which was clubbed together with this case, that is the BPC 69 of 2018. It was disposed of by this Honorable Court order dated 20 June 2025, given directions to the respondent to consider as to whether the case of the petitioner falls within the purview of CCS Extraordinary Pension Rule 1939, and to consider the case of the petitioner within 4 months from the date of this order. But the State Council rejected the claim of the petitioner. Why?
Rejected?
Yes, stating that the petitioner case does not fall within this purview. So in this case, we're preparing for a review. So this matter 43 and 44 may be listed after that review is
After
filed.
the disposal of that review.
Yes, Lordship.
What is the review petition number?
No, it's yet to be filed. We're under preparation.
You are yet to
Yes,
file.
yes, Lordship.
In that case, we'll just list it after 4 weeks,
Okay.
and then during that time you file.
Yes, Lordship.
Learned Counsel for the petitioner, MS such and such, prays for listing the matter. This is 43 and 44, okay? Matter after 4 weeks. As she is contemplating to file a review against the order of this court passed in a similar case. So, list after 4 weeks. The prayer is not objected to. Who's appearing for the state respondent? Prayer is not objected to by the.
Your Lordship, I'm mentioning on behalf of Tiba.
Okay, Government Advocate, Mr. Tibako. Stop list after 4 weeks. Yes.
For motion, item number 2.
May I, Your Lordship?
Yes.
Lordship, it's I'm here for this anticipatory bail, and this all about an affair which is there at page 10. And basically, this affair says that I have.
Wait, there is an order of this court dated 23/10. It
For
says-
filing of additional
uh,
affidavit.
It says that a civil suit arising out of the same issue has been filed by the complainant before the civil judge senior division.
Yes.
In view of this aforesaid filing, he submits that he wishes to bring on record such and such, so additional affidavit filed.
Your Lordship, I received this morning only, Your Lordship.
Okay. It's not on record.
Yes.
You filed it this morning?
Yes, yes.
Okay, we'll take it after some time. Just call for the affidavit, okay?
Highly obliged.
For motion from the supplementary course list, item number 55.
Just call for the affidavit, no, yes.
May I please, Your Lordship? Lordship, here the petitioner is seeking for pre-arrest bail in connection with the Lazu PS case number 2 of 2025 under sections, Lordship, 111 clause 2B, 1111 clause 4, and 305 clause 5 BNS, read with section 13(1) UAP, which is in connection to the Lazu PS at Arunachal, Lordship. Lordship,
Arunachal?
Yes, Lordship. This is under the district of Tirap, Arunachal Pradesh, Lordship. However, Lordship, the petitioner has received a notice which I have annexed in my annexure G, which is at page 16, Lordship. Lordship, here the petitioner is now he is presently residing at Dimapur, and he has a business there set up in Dimapur. And in connection to, he was informed that in connection to this Lazu PS case, there is a transaction made, some of the transaction which is alleged to be of an extorted money has been transferred to the account of this the present petitioner's, Lordship. However, if I may take to the...
No, but the case is in connection with
Yes.
with the case in Arunachal Pradesh.
Yes, Lordship.
Then how can this court have the
Lordship, this honorable court has the power to grant a transit bail, Lordship. So I have approached this honorable court to grant some temporary relief so that he can appear before the Lazu PS, Lordship. In fact, Lordship, I have the citations also by the apex court as well as this honorable court passing the similar matters, Lordship.
No, but how can the PP also get the required instructions from the
Lordship,
IO who is in Arunachal?
yes, I have impleted the IO of the case, represented State of Arunachal as a respondent number 1 and represented by the IO, Lordship, and also the PP as the respondent number 2. Since the petitioner, he got the contact numbers and everything from the East Police Station, Dimapur, so that is why we have impleted the state as the respondent number 2, Lordship.
Who's appearing, PP?
Bishop of State of Nagaland.
Have you gone through?
Only this morning I went through a glance, but we don't have much role. At the same time, now my learned friend has been submitting that it's a transit bail, but the glance I went through, I don't see anything mentioned.
Lordship, the transit bail can be granted under
but-
the same section, Lordship. I have a citation and also the of the apex court as well as this honorable court, Lordship.
That is one thing. Then another aspect is the jurisdiction.
Lordship, that is why it's a transit bail, Lordship. If I may be allowed to place some reliance, Lordship, so that it will clear the doubt of this honorable court, Lordship. Lordship, the first one is 2021 SCC online Bombay, Lordship. That is Nikita Jacob. The relevant paragraph is 12, Lordship.
Yes.
If I may be allowed to read. Para 12. I am in agreement with the view expressed by this court in the case of the Javed Anand and in the case of Sanuta Muluk Supra. Temporary relief to protect the liberty and to avoid immediate arrest can be granted by this court. Generally, the power of the High Court in the anticipatory bail application are limited to the territorial jurisdiction. However, Lordship, as observed in the case of the Javed, there may be cases where if the protection is not granted, liberty of an individual would be jeopardized. The real cause of making application under Section 438 is proposed arrest of person. In the present case, there is no apprehension of this. So in this case, there was no apprehension. Here, in my case, Lordship, there is apprehension of the arrest of the present petitioner, Lordship. And also, if I may be allowed to place the another lines, that is Amita Garg, that is reported in 2022 SEC Online, Allahabad. Lordship, here I'm relying on the para 9 to 13 and also 16. However, the most relevant is at para 16, Lordship. In view of the law enacted in the above referred cases, there is no feature on the part of the High Court in granting a transit anticipatory bail to enable the applicant to approach the court, including the High Courts where the offense is alleged to have committed and in case registered. There is no doubt that the right to liberty is enshrined in the Part 3 of the Constitution of India, and such right cannot be impinged except by the following procedures established by the law. This court finds that the commercial transaction is in between the applicants and the complainant, and there are criminal cases lodged by the parties against each other. It is a fit case where the applicant should get the privilege to transit pre-arrest bail in the light of the other past in the case of Nikita Jacob Supra. And Lordship, these two citations has been approved by the Honorable Apex Court in the latest judgment, that is 2024 for SCC 749. Lordship, here I am relying on the para 102 and 103. Lordship, here also it has 102 and 103. Here the Apex Court has also held that the pre-arrest bail can be granted to a temporary release so that he can approach the appropriate forum. These are on the same principles of law, on the same principles, Lordship. If I may be allowed to read again, Lordship.
Yes, 102.
At para 102. At the same time, we are also mindful of the fact that the accused cannot seek full-fledged anticipatory bail in a state where he is a resident, where the FIR has been registered in a different state. However, in view of what we have discussed above, he would be entitled to seek a transit anticipatory bail from the Court of Session or the High Court in the state where he is a resident, which necessarily has to be of a limited duration, so as to seek a regular anticipatory bail from the court of the competent jurisdiction. The need for such a provision is to secure the liberty of an individual concerned. Since anticipatory bail, as secured, yes, well as the transit anticipatory bail are intrinsically linked to personal liberty under Article 21 of the Constitution of India. And since we have extended the concept of the access of justice to such situation, and bearing in mind Article 40 thereof, it would be necessary to give the constitutional imprimatur to the involving provisions of the transit of the anticipatory bail. Otherwise, in a deserving case, there is a likelihood of the denial of the personal liberty as well as the access to justice for by the time the person concerned approaches the court of the competent jurisdiction to seek anticipatory bail. It may be well too late, as he may be arrested. Needless to say, the court granting transit anticipatory bail would obviously examine the degree and seriousness of the apprehension expressed by the person who seeks transit anticipatory bail, while the object underlying the exercise of such jurisdiction is the thwart arbitrary policy action and to protect the personal liberty beside providing immediate access to justice through within a limited conceptions. Para 103. If a rejection of a plea for limited or transitory anticipatory bail is made solely with reference to the concept of territorial jurisdiction, it would be adding a restriction to the access of power under Section 438. This is our view would result in a miscarriage and travesty of justice, aggravating the adversity of the accused who is apprehending arrest. It will also be against the principles of access to justice. We say so for the reason that an accused is presumed to be innocent until proven guilty beyond reasonable doubt, and in a and in accordance with law. In the circumstances, we hold that the courts of session or the High Court, as the case may be, can exercise the jurisdiction and entertain the plea to the limited anticipatory bail, even if the FIR has not been filed within its territorial jurisdiction, and depending upon the fact and the circumstance of the case. If the accused apprehending arrest makes out a case for the grant of anticipatory bail, but having regard to the fact that the FIR has been not registered within the territorial jurisdiction of this High Court or the session, as the case may be, at least they consider the case of the accused for grant of transit bail, which is an interim protection of the limited duration till such accused approaches the competent session or the High Court, as the case may be, for seeking the full-fledged anticipatory bail. So,
Okay, where do you show that the apprehension is there? Let's see, in your pleadings.
Lordship, it's the notice, Lordship.
Notice, oh,
Page
okay, page
16 of my petition is, Lordship. And in fact, Lordship, his bank account has already been frozen, Lordship. And the notice, he is supposed to appear today, Lordship.
before that,
Lordship, yes, Lordship. Lordship, I also have two similar cases which has been passed by this honorable court. If I may be allowed to reproduce. Lordship, here also the FIR was registered in another district, one in Assam and one in Uttarakhand, Lordship. So Uttar Pradesh, one was UP. And here this honorable court has also granted interim bail so that the petitioner can approach the appropriate forum and to file the...
But in your prayer, have you stated that transit?
Lordship, I have not seen, so it's under the...
It's not there.
Yes, Lordship, I have thought as under 482, Lordship. Since it's an anticipatory or transit, so I have not specifically mentioned. However, Lordship, in one of my paragraph, I have stated that I have approached this court, though the...
Where's your, in your pleadings?
Yes,
Either in
Lordship.
your pleadings or in your prayer, you have to state
In my
somewhere.
prayers, I have stated in the para 9 that though this is not within though the FIR is lodged at, and he being the resident has filed this for the protection of, before this honorable court,
No,
Lordship.
that's right, but then you have to state somewhere in your pleadings that the apprehension of arrest is there, so the transit bail may be allowed so that you will go and appear before the competent
Lordship,
court. So that is not there.
I have not specifically mentioned, but it's since it's anticipatory or the transit, so...
No, because if it's a normal anticipatory bail, this court cannot allow. Okay, the territorial jurisdiction is there. But if you say transit anticipatory, then it can be allowed as per these judgments. But in your prayer as well as in your pleadings, there's nothing. Can you just withdraw and file tomorrow?
Lordship, he is appearing, in fact, Lordship, even my sincere apology, but his
one
notice is to the
paragraph you
Lordship.
add, just one paragraph.
Lordship,
We'll take up at 2.
this court has the power to, Lordship, under 482, since it's a badness, so Lordship.
Right, power is there. I'm convinced that now power is there. But
Lordship.
then without any pleadings and without any prayer, that is the problem.
Lordship, it's under, the section is given, the section
No,
is
section
specifically...
is anticipatory bail, section is anticipatory bail, okay. So you refile, just add one paragraph saying that you apprehend arrest in such and such case and you require a transit anticipatory bail in order to enable you to approach the competent court. Okay, that much only. And then we'll take it up at 2. Okay.
Lordship, in that case, allow me to file in the form of affidavit, additional affidavit, Lordship.
Okay.
Otherwise, the process will be long. Much obliged, Lordship.
List at 2. Okay. 2.
For motion, item number 2.
2. That's all.
Your Lordship.
Yes.
Lordship, in this additional affidavit, I just wanted to brief that a civil suit was filed before the Civil Judge Senior Division, Kohima. And of course, in the cause title, it was written civil defamation. But the crux of the said case is that claiming the defrauded money of nearing 1 crore compensation is claimed. And the summon is also annexed here, which was sent to me at page 6 in this additional affidavit claiming that 1 crore. Your Lordship, I have entered appearance in that civil suit. And in fact, the Wakalatnama is also filed there through my lawyer. And why I could not join the investigation, Your Lordship, I have explained that at page 3, para 6 of this additional affidavit, that actually the informant called up my wife and he has threatened that even if the police gives me bail, he has other means to take care of me. These were the words used, and there is no ifs and buts to that. I am ready to join the investigation. I have entered appearance in that civil suit, and I am ready to cooperate in this the affair which is filed against me. Only I require an interim protection before this honorable court, and therefore I am here before this honorable court.
So there is a civil suit as well as FIR was filed.
FIR was filed. FIR was filed on 14th April 2025. And the FIR says that there was some fraudulent transaction of 10 lakhs, of 5 transaction of 10 lakhs. And those dates back to March 2024. But however, I was working in that firm till October 2024. They've used the word that I fled away and my whereabouts are not known. But the fact that the summon, in fact, which was sent to me, there also exact my house number and everything is there. So question of me fleeing doesn't arise here. I'm ready to join the investigation, Your Lordship. I just humbly pray for an interim protection. That is my humble submission.
Do you have instructions?
No, Your Lordship. Your Lordship, as far as the FIR is concerned, it relates to criminal breach of trust, cheating, and forgery, Your Lordship. And the civil suit that is apparent from the record, Your Lordship, it is for, as stated, Your Lordship, it is for defamation and defamation for compensation of 1 crore, Your Lordship. Here it's relating to 10 lakhs, Your Lordship. So, Your Lordship, these two might be different, Your Lordship. Maybe, Your Lordship, here and there, we have to see the record, Your Lordship, as to how he has been defamed and as to why the compensation of 1 crore is seeking, has been sought, Your Lordship. But as far as this is concerned, yes, Your Lordship, I'm coming for the, I'm appearing for the first time, Your Lordship.
Okay.
So, let the city
Okay, then we
be
will
called
issue
for,
a
Your
short
Lordship.
notice.
Yes, Your
Of
Lordship.
course, give some interim protection also. After a week,
No problem, Your Lordship, after we.
the petitioner herein has filed an application, this application under section 482 BNSS, praying for pre-arrest bail in connection with Sechu Zubza police case number 2/2025 under section 316/318/336 clause 2 and 3 BNS. Stop. The Learned Counsel for the petitioner, Mr. P. Chanda, submits that the FIR was lodged by the complainant, alleging that the petitioner, who had worked at the service station as an assistant manager for the past 10 years, had defrauded/cheated an amount of rupees 10 lakhs each on 5 different occasions, that is 4/3/2024, 4/3/2024, 10/5/2024, 17/5/2024, and 28/5/2024 by making false/fraudulent bills. It is alleged that the petitioner was also found engaging in malpractices in the service station by issuing fraudulent invoices amounting to rupees 8 lakhs in October 2024. The petitioner submits that he was a mere employee of the service station and not an assistant manager as alleged in the FIR. It is also stated that the FIR was lodged only on 22/4/2025, around 6 months after the petitioner had already left the job. Stop. It is Para, it is further submitted that the petitioner has received summons to appear at Sechu Zupza Police Station on 15/9/2025 at 16:00 hours for questioning. The said notice was received only after the expiry of the given date. Stop para. It is also submitted that the civil case being civil suit 6/2025 arising out of the same cause of action is also pending before the Court of Civil Judge Senior Division Kohima. Stop. To this effect, the petitioner has filed an additional affidavit bringing to the notice of the court the dependency of the said civil suit. Stop. It is therefore stated that the petitioner is ready to comply and cooperate for a speedy disposal of the civil suit and also the criminal case against him. And therefore, the question of absconding does not arise. Stop para. It is therefore prayed that the petitioner may be granted pre-arrest bail pending investigation in the said matter. Stop. Issue notice returnable within 1 week. Stop. Learned PP Ms. Livika has accepted notice on behalf of the state respondent. Therefore, no formal notice is called for. Stop. The PP shall produce the updated copy of the case diary on the next date. Stop. Till the next returnable date, in the event of arrest, the petitioner shall be released on executing a bail bond of rupees 30,000 to the satisfaction of the arresting authority. Stop. List on, let's give a date after 1 week. 17th. List on 17th.
Your Lordship.
17/11/2025. Yes.
For admission, item number 24.
What is this?
My lord, this petition is regarding land acquisition by the central government. Now, altogether, 7th adjournment has been granted to the petition respondents. And on 7th August, Justice Susmita Purkan gave a last order for adjournment. But then even after that, 2 times adjournment was given. And today also, I don't know whether they have filed their reply or not. So my prayer to this court is to pass a no-say order in this matter, and hearing may be fixed for submission of argument for the petitioner for admissions of these petitions. Because there's an urgency. Construction begins in December 2024. And now it is almost about to be completed. And my lord, the respondent has not taken any steps according to law. Just randomly, they have started constructing the road, and despite the prayer of the petitioner to furnish the gazette notifications as per law, they did not furnish us any gazette notifications. And they have started constructing the road, and it is almost about to be completed. So, no further adjournment should be granted to the respondents, and the court should pass no say order in this matter. And the next date should be fixed for submissions of arguments for admission of this petition, because still not the petition remains fresh.
The respondents have been praying for adjournment one after another, and almost 7 months has passed.
Notices on all the respondents' complaints.
Yeah, yes, sir.
Lordship, I may be
As per
allowed
the
to-
last order, Justice Kalini Rai Soran has clearly mentioned that.
Lordship, I may allow to
8-9.
clarify the proceeding. Even though the petition was moved on 20th March, the petitioner has, the notice has been affected on the respondent number 1 and 2, that is a principal respondent, only on 8th September.
8 September.
8th September, yes. Throughout those months, the petitioner could not be completed the notice upon the principal respondents. So on 8th September, the matter came up.
R1 and 2.
Yes. And in the morning, the Honorable Court had detected that no notice was affected on the respondent number 1 and 2. So petition was granted after lunch break to complete all the process. Then the matter was again taken up after lunch break. So by the lunch break on 8/9/2025, the order is very clear. In the morning hour, the petition was granted to complete a notice upon the respondent 1 and 2. And by the matter was listed after lunch break, so it was shown as completed. So until today, the respondent 1 and 2 are not responded now, even though I'm appearing on behalf of the state. And here,
But state
No, no.
is a necessary party.
no, I'll come. The state is only a facilitator here in all those road construction. And Lordship here, the BWD National Highways and Nodal Department, in all the road construction in the state of Nagaland. But we were not implemented as a party. So I am also facing a lot of problem to get the information from the concerned department. Since the Chief Engineer of the BWD National Highway is not a party, and Commissioner Secretary Land Revenue, of course, it was implemented as respondent, but in the construction, the land revenue is totally, they cannot say
They are only
anything.
for the acquisition.
Yes,
Land
only
revenue
for
is
acquisition. But construction is
For construction, it will be national highway.
yes, that is a
Chief engineer.
necessary party. So unless the party is implemented, even though I am just primarily disclosing all the facts, but without that, we also cannot move. And unless a principal respondent or responded, then we
And
are.
1 and 2 CGC is not appearing. If they are
No, no.
served notice now.
Yeah, I do not know, but whether they have received all the copies or not. But the problem here is, as per the procedure and as per the proceeding, unless a principal respondent responded, we just cannot force the state government to respond in one way.
May I submit, my lord?
What about NHIDCL? Are they
No.
also necessary party?
I think this project is handled by the.
No, my lord, NHIDCL is not a necessary party to the case.
MOT, this is
More. It is purely central. Regarding land acquisitions and fixation of rates of land or damaged property and hearing of claims and objections, everything is statutory. And this NHIDCL is only a company which was formed only in 2015 under the Companies Act. It was not formed under the Act of the Parliament.
No,
They formed and they are a contractor. They are concessionaries.
It has to be
And if
approved by
at
the
all,
petitioner,
the learned
whether-
council want to
whether
submit
the
something,
notices
they should file in the affidavit.
received by the respondent 1 and 2. We have to see the petitioner has to.
And actually, this was
confirm.
formed only in 2015
The thing is,
under the Companies
there is
Act.
an order of 8/9/2025.
Yes.
Which says that this court is inclined to hold that notice on respondent 1 and 2 is duly served.
Okay.
Yes.
But till now, it is not respondent.
That is 8/9/2025. This is basically for compensation, isn't it?
Acquisition,
The
my lord.
prayer, the prayer.
Acquisition with compensations.
Acquisition and compensation.
Yeah.
So without the respondents 1 and 2, this cannot be disposed of.
Your Lordship.
Yes.
But they have already been served, and this court has observed on 8/9/2025 by Justice Kalani Rai Surana. And he has clearly mentioned the court is inclined to hold that the notice on respondent 1 and 2 is duly served. None appears on call for the said respondents. Until now, they have not replied. And how long shall we go on like this?
No,
Seventh adjournment is too much.
Thereafter,
my lord.
whether another notice is served or not, it is the duty of the party.
Oh, already, even the court has
Petitioner
already
is a
reflected in the
dominant
order,
status. It is
in
his
the last
case.
order.
He is the master of the petition. So a step has to be taken. Otherwise, by just pushing that cannot meet the purpose. We have to comply all the procedures.
I think we'll take the assistance of the CGC.
Lordship.
Because without him, I don't think we can progress. Okay. Learned counsel for the petitioner, Mr. N.K. Asumi is present. Stop. Learned additional AG, Mr. In Tim Song appears for the
State respondent.
respondents. State respondents number 3, 4, 5 and 6. Stop. None appears for the respondent number 1 and 2 when the matter is called. Stop. By an order dated 8/9/2025, this court had stated that the notice on respondent number 1 and 2 is duly served. Stop. However, till date, there is no representation by the respondents 1 and 2. Stop. List after 3 weeks.
Yeah, Mr. Yes.
List after 3 weeks. Stop. On the next date, the learned CGC is also directed to be before the court and to assist the court with regard to the service on the respondent number 1 and 2.
1 and 2.
Okay.
And my lord, I would pray to this honorable court to make it a last adjournment.
No, we'll see. Because there will be no effective disposal if 1 and 2 are not present.
Yes.
Okay. So we'll see on the next date what can be done. Yes, at least after 3 weeks, a copy of this order may be furnished to the learned CGC.
For motion, item number 39. For orders, I beg your pardon.
My pleasure, Your Lordship.
Yes.
Lordship, here I'm appearing on behalf of the Learned Counsel, Mr. B.N. Sharma, for respondents 1, 2, and 3. Lordship, I'm
They were
informed.
to file an objection. What
Lordship,
happened?
I'm informed that the appellant has not yet served a copy of the
Appellant
IA.
has not served a copy of the IA.
All of the IA.
Oh. Who's appearing for the appellant here? 29. Nurul Hassan, Sumika Kati. Okay. Learned counsel, Ms. Such and such appears on behalf of Mr. B.N. Sharma for the respondent number
1, 2, and 3.
1, 2, and 3, and submits that a copy of the IA 17 of 2025 has not been served on the respondent. Stop. The counsel for the appellant is directed to serve copy of the IA on the learned counsel for the respondent within 1 week from today. So thereafter, list the matter after 2 weeks.
For orders, item number 40.
May I please, my lady?
Yes.
My lady, this IA is for deletion, striking out the name of some petitioners. My lady, here, the 7 petitioners, The fact is that they never, in fact, they had not engaged or entrusted anyone to file the ongoing writ petition. So, instead of going deep, our humble prayer is this Honorable Court may be gracious enough to strike out our name from the list of petitioners.
Okay. Learned Counsel for the applicant, Mr. Fonseca, for the stop. In the present application, the applicant states that the applicants recently came to know that the connected writ petition, WPC 162 of 2025 was filed jointly by aggrieved graduate teachers and others, impugning the graduate teachers' final seniority list of 2025 under preparation for publication, wherein the name of the applicants had been entered at serial number 2, 3, 12, 14, 24, 31 and 34 in the list of petitioners in the connected writ petition. Stop. However, the applicant states that the applicant had no knowledge about the WPC 162/2025, nor did the applicant authorize any individual to approach the court for filing of the connected writ petition 162 of 2025. Stop. Para. It is therefore prayed that the names of the applicants may be struck off from the array of writ petitioners in WPC 162 of 2025, as the applicants are not interested to contest in the writ petition. Stop. The prayer is allowed. Learned Counsel for the petitioner. Learned Counsel for respondent.
I'm for the respondent.
Respondent such and such.
I'm for the
Is
rest of the
present.
petitioners.
Okay, and Miss such and such appears for the other petitioners. Mr. M.T.M. Sumlanat AG appears for the state respondents. So, accordingly, the applicants' names, whichever is the list given, the applicants' names,
Page 61.
applicants' names, which are petitioner number 2, 3, 12, 14, 24, 31, and 34 in WPC 162 of 2025 may be struck off from the array of petitions. So, application stands dismissed.
Obliged, Lordship.
And in the main case,
My Lord, in the main writ petition, I'm appearing for some of the respondents. If I may be granted 3 weeks' time to file my counter, my Lord.
Yeah, Lordship, instead also, we have not filed an appeal.
state has not filed. Learned Counsel for the petitioner, MS such and such is present. Stop. Learned Counsel, Ms. Lucinio appears for some of the respondents. Number.
Lordship, if my lady can kindly peruse the order 22/9/2025, it's reflected in the order. It's quite a few of them. So, and if my lady, if respondent number 22/9/2025,
Just see the order dated
and if
22/9.
respondent number 13 and 59 can also be added in the list, my lord. We are appearing for 2 more.
Stop. Such and such, and then in addition, she also appears for respondent number
13 and 59.
13 and 59. Stop. And Learned Counsel prays for how much time?
3 weeks time.
3 weeks time to file her affidavit in opposition on behalf of the above mentioned respondents. Stop. Learned Additional AG also prays for 3 weeks time, also makes a similar prayer. Stop. Prayer is allowed, list after 3 weeks.
Lordship, we may file a fresh amended cause title.
I think deletion can be just made, no?
Okay, then. Okay.
You make the deletion since the order is there and then put your signature.
Yes, Lordship. Thank you.
For hearing item numbers 41 and 42.
what is this?
My Lord,
Lordship, before we proceed, Your Lordship, the counsel for the CBI is absent, Your Lordship. Respondent. So
Who's
if this,
appearing, CBA?
so if this Lordship desire that we continue, then no problem. However, Your Lordship, before we proceed.
What about CGC? Because in the last order, Mr. Yang Narwati, CGC for Union of India.
Yeah, he's also absent.
Yangwati is in the chamber. I can send for him.
CBI is necessary party.
My Lord, what I'm bringing is that somebody died in the custody.
Custodial death.
Yes, the whole family, they are totally in the dark. So, since it is an action of the police, Nagaland police, I want an independent inquiry.
So that means you want an inquiry by the CBI?
My Lord, that is my prayer, specific.
Why can't it be done by the police?
They have done it,
Oh,
but
they've done
it is, yes, it is more or less of a covering of their action. There was an inquiry by the district and session judge.
Inquiry by district session judge also?
My Lord, we were not allowed to participate by the council. Yes, two of them were examined, but it was in the camera. So this cannot be called an inquiry. Why does it have to be in so secretive way?
We can direct for a fresh inquiry then?
Your Lordship, we have to hear the case properly. Then only, Your Lordship, we have to see whether the inquiry of the CBI will be required or not, Your Lordship, because we have not gone into the merit of the case. Let's discuss like the matter, hear the matter, then only this Honorable King can decide. If it deems that no, you should go, then we will go.
If it does not done properly, the inquiry,
yes,
court can always direct for a fresh inquiry
yes,
also.
no problem for that. However, Your Lordship, is a 2016 case, and so many efforts has been made, Your Lordship, in this case, and we have to hear it intensively, and we are also actually, we should dispose this matter because it's 2016, it's a long pending case. However, my only thing is that...
No, because CBI inquiry court cannot just direct,
No,
randomly.
Yes.
We cannot.
My Lord, what I'm saying is this, with due respect to my learned friend, somebody died.
Yes.
In a police custody, if it was unnatural death, whatever, outside, that's a different thing. So what I am praying to my learned friend also is that we should try to find out the truth.
Your Lordship, I respect
I may not have a case. After proper inquiry, so I don't think there is any room for any argument.
No, I respect that, Your Lordship.
Have a proper inquiry or not? That should be the first issue.
It was heard earlier.
Yes, on many occasions,
Then why no conclusion?
Your Lordship, the issue took time. I don't know, Your Lordship. We were
Written
always
submission
on
is
the.
also there.
It's always there.
Written submission of the petitioner is also on record.
Your Lordship, I have clearly pointed out how the inquiry was conducted.
At least we need to have a first submission, and the court can also come to a judicious conclusion. That is my humble prayer.
Retain the nature of mandamus to direct the respondents to conduct and complete the investigation with respect to the death of late Jalaluddin. Okay, so what happened to that? That is one of your prayers. to direct the respondents to conduct and complete the investigation
My lord.
with regard to the death of such and such. So that investigation is completed.
Yes, we have we have a magistrate inquest report, and during the hearing, Your Lordship, this honorable court has directed for inquiry also, and therefore, a district and sessions judge was appointed
that
to
was
go.
directed
Yes,
by the
that
court.
was
By this court.
but the petitioner was not satisfied with that also.
No, it
So
is
that
not a question of my satisfaction or not.
He
Whether
wasn't
the
given an
rule were
opportunity. That is
followed
what
or
he
not.
has said.
No.
So we need to have a
Whenever this
proper
honorable court directs
adjudication.
inquiry, the government side give every right. So also with
Yes, everyone should appear and
my lord,
participate.
that is what I am saying. If it can be done in that manner, that
So we have to see, Your Lordship, after hearing all the parties, Your Lordship.
So finally, what did the district and session judge say? As per the findings, no suspicion and evidence
no
of
suspicion.
any foul
Everybody
play could be
is
found on the
yes.
part of the South Indian.
Now, the whole case of the petitioner is that they are saying that because of the torture meted out to the accused has died, Your Lordship. But, Your Lordship, nothing on the record shows that there was a torture. So the petitioner has to satisfy this court how torture has been meted out. All the averments is all about torture being meted out. Now the court has to be satisfied what torture that has been meted out. If the torture is being meted out and because of that the accused has come to death, then, Your Lordship, the compensation arises. Or maybe the court has other means of compensation, but that too we will come later stage. But as far as the torture goes, because whole of the case revolves all about torture being meted out to the accused, and because of that the accused come to death, Your Lordship. So that's why my humble
Police
submission.
investigation already done, nothing
Yes.
is found. Then magistral inquiry by district and session judge done.
Yes.
They didn't
Nothing
find
is-
anything.
yes.
So now, what can this court do except grant some compensation? If at all.
Human Rights Commission, they have awarded 5 lakhs to
That is human rights.
Okay, human rights can grant, this court can also grant, even if human rights has granted, that is, there's no bar.
No.
Your Lordship, there should not be double this thing. Suppose if either of the one, if they make a payment.
No,
then
it
will
doesn't
go.
prevent this honorable court.
It doesn't
No.
prevent the
No.
court from
No, Your
granting
Lordship, I think
compensation.
there is I think we will have a ruling to support that.
In one interesting aspect of the matter, this direction of the Human Rights Commission was produced by the government.
Yes.
And they are saying that it has not been complied with.
Because there should not be double payment for civil liability, for the liability, Your Lordship. Ipsa liquidator, Your Lordship. But that's why, Your Lordship, I make it a point that I bring it before your court, so that the court can make a judicious conclusion, a fair conclusion, Your Lordship. If this Lordship feels that we can proceed without the counsel of the CBI, then Your Lordship, we can.
No, the only thing this court would like to get from the CBI counsel is, see, when police investigation is already done and when the district and session judge has already conducted an inquiry, whether referring it again to the CBI, will it serve any purpose? That is the thing. And when it happened in 2016,
yes.
Right now, we are now in 2025. So, the same witnesses, the same people will come.
Only
for
the
any
thing is that
investigation.
what I'm
So
saying
what
is-
will they prove more?
No,
Yes.
we are not allowed to cross-examine any of the witness. They are saying that somebody have filed a FIR in the police station. The person was never called in the inquiry itself. That is the first thing is
No,
somebody.
that's why I'm saying fresh inquiry,
My lord,
and then we'll
Our
give a direction to
submission.
hear all the parties,
My
give
lord.
an opportunity to
my
cross-examine the
lord,
witnesses.
that will serve the purpose.
That will serve their
My
purpose,
lord,
isn't it?
yes.
What do you say?
Fresh inquiry from.
By the district judge, sessions judge?
In
Since
the first
petitioner is
place,
not satisfied.
had we been allowed, everything should have been
Were they allowed to cross-examine and all that?
Cross-examine, Your Lordship, that has not been done. Your Lordship, it is just an inquiry, like direction to the district and sessions judge to inquire into the matter, Your Lordship. So the district and session judge, in his
No, my
own
lord,
capacity,
what
has
I'm saying
inquired, he
is
has called the doctor concerned who has examined. Except 2 or 3 already died, Your Lordship. Otherwise, Your Lordship, the rest of the person who were there, they were examined, Your Lordship, and even the 2. The brother was also called and they were examined. Now, whether in the inquiry the cross-examination is required, Your Lordship, my humble submission
My
is...
lord, if I am...
No, opportunity has
Yes.
to be given.
So they were examined, Your Lordship. They were examined. They were also called. We can see from the inquiry,
My
Your
lord,
Lordship.
the 2 brothers, you were called. So, from the T1, we were present, but we were not allowed to participate. That is the whole issue here.
I don't know who.
In
then-
Participate means you were called, your statement was recorded.
Yes.
My lord, that two witnesses, you were called, examined.
So what government advocate is saying also, there's a point there. Because it's not a trial.
No.
An inquiry is not a trial.
No.
So whether you should be given the opportunity to cross-examine the
My lord,
witnesses.
that is what I've stated in my
I
written
think
submission.
that is beyond,
Written submission. Because
beyond the scope of inquiry, I think.
Yeah, that too.
Cross-examination.
Actually,
Because after examining all the witnesses, the inquiry officer will come to a conclusion, finding.
Yes.
That's
Just
all.
a finding, and basing on the finding, this court has to come to a judicious
my
conclusion.
lord,
That's it.
my written submission, para 3 maybe, please look into.
Your Lordship, we can have a
The rule is
intensive
very
hearing, Your
clear.
Lordship.
The law is very clear on that line.
Starting from the facts of the case, Your Lordship. So that this court can also be aware of the facts of the case, and how this inquiry has come about, how the subsequent order has come about, Your Lordship.
Para 3.
Yes. Page 4.
Right of cross-examination representation. Right of cross-examination. Just of machine. Okay, we can give a direction.
Your Lordship, if we can come to the inquiry, Your Lordship. An inquiry, Your Lordship, we have to say section 8C about about the commission as to how this section apply, whether this section can really apply in the case of the petition. However, in inquiry report, page 54, family members of late Jalaluddin. Ansar Ali is the one who has filed the case, Your Lordship. 54:15.
Yes.
15, that is Ansar Ali who has filed this present case, and 2, close to also Lukman Uddin, complainant. Your Lordship, so both of them have been examined. They are the family members of the accused person, Your Lordship. So inquiries, they have to come, they have to give their statement, and on these findings, the district and session judge gave a report. So I don't know, Your Lordship, how we should cross-examine. We have to see this section, how this section will apply, Your Lordship, and how the direction was issued to the district and session judge to go for inquiry report. We have to see whether this inquiry and this.
Where is the order directing the district
Your
and session
Lordship, it
judge?
was passed
Order dated?
4/6/2024.
4/6.
It's not a commission, it's an inquiry to inquire into the matter. The appropriate government, Your Lordship, we have to see the section properly. We have to see whether this section 8C applies in our case. 4/6/2024.
This court therefore directs the fact-finding inquiry.
Yes, fact-finding inquiry. It's not a commission. Whether it will come under a Commission of Inquiry Act.
See, there are many commissions set up by the government also
Yes.
with regard to firing incidents or death of civilians in all those things. So when this commission sits, then they just call for the witnesses to come before the commission and they give their statements. So there is no occasion where they are being cross-examined and all that in these commissions. So it's a similar commission. This one also it's like an inquiry.
My Lord, fact finding, if it is let's go by the fact finding, then let there be a judicial inquiry where both the parties will be allowed to participate.
That's why they were there. They were called.
No, my Lord. What I'm saying is, when there is an inquiry about somebody's death, when it is inquired into, both the sides are allowed to participate.
No, see, this court also feels that there should be a fresh inquiry. But what kind of inquiry?
Yeah, that's why.
So let's take it up tomorrow, and then you also do some research, and then I'll also think about it.
Yes,
and then
yes.
let Pendang, what's
Yes,
his name?
he has to
Pendang
come.
Wabang.
Let him also come because it's a long
My Lord,
pending case. I want
as
to
your
finish
Lordship
it.
has pointed out,
No, but we cannot dispose now again
Yes,
because
that's why.
fresh inquiry and that report has to be awaited. No?
That has to be. But firstly, before coming to that conclusion, at least let us give our submission. Then the court can decide. Okay, I think we need to have a fresh. If this court comes to that conclusion, also at least give us a fair submission.
I've seen the report now. I've seen the findings also. The statements have all been recorded, fine,
Yes.
that's fine, but the petitioner is aggrieved because he was not given an opportunity to cross-examine the witnesses, that's all.
Now, whether
So-
that is applicable.
So, no, that's why I'm saying, that's why I'm saying, you also do your homework.
Yes, yes.
Because there are different kinds of inquiries. Like I said, commission is there,
Yes,
fact-finding
yes.
is there, inquiry, judicial inquiry is also there. So these are the different kinds of inquiries, so we have to see whether that provision can be given in the order of this court while directing for inquiry, okay? So that is the only thing which we need, because besides that, there's no other thing right now to be decided. So can Pendang be here tomorrow
That is the.
We
or
can,
Monday?
Monday?
Monday, Tuesday,
We can
because Monday.
inform him.
Okay, you inform him,
Monday.
this is the matter.
November.
11th, Tuesday will be 11th.
Your Lordship, if we can make it on 13, Your Lordship, because I
13.
have difficulty on 10, 11, 12.
Okay, 13. List on 13. As
And we can
item one.
inform.
Item 1 in the hearing list.
Much obliged.
Molo Chit.